Section 22, Assistive Animals Q&A, Today's Fair Housing Rules and Regulations, 2026 Standard. Introduction, Taking Assistive Animal Compliance to the Next Level. In the last section, we broke down what assistive animals are, why they are not considered pets, and how housing providers must treat them under fair housing law. Now we take that knowledge and apply it in real-world situations through a legal hotline-style Q&A format. This section builds directly on Section 21 and ties back to earlier discussions on reasonable accommodations, disability protections, and policy enforcement. In 2026, most violations involving assistive animals don't happen because someone doesn't know the rule. They happen because someone applies the rule incorrectly in a real situation. This is where you sharpen your decision-making. Scenario 1. What if there is a no-pet policy? A tenant applies for a property that has a strict no-pet policy, but requests to bring an assistance animal. The housing provider initially denies the request, pointing to the lease rules. This is a violation. An assistance animal is not a pet, and housing providers are generally required to make exceptions to no-pet policies as a reasonable accommodation for individuals with disabilities. This ties directly back to Section 21. Policies must be modified when they conflict with fair housing protections. Scenario 2. Can you charge a pet deposit or extra rent? A landlord says, "We allow the animal, but you still need to pay the pet deposit and monthly pet rent." This is also a violation. Housing providers cannot charge deposits, fees, or additional rent for an assistance animal. However, tenants can still be responsible for actual damage caused by the animal, just like any other tenant would be. 2026. Rule: no upfront fees, but accountability for damage still applies. Scenario 3. Breed, size, and weight restrictions. A property has a rule banning certain dog breeds and limiting weight. A tenant's assistance animal falls into one of the restricted categories. Can the property deny the request? Generally, no. Breed, size, and weight restrictions do not apply to assistance animals. However, there is an important exception. If the specific animal poses a direct threat to safety or would cause substantial property damage, it may be denied. That determination must be based on actual behavior, not assumptions or stereotypes about the breed. This ties back to earlier sections on discrimination. Decisions must be based on evidence, not fear or bias. Scenario 4. Insurance restrictions and breed limitations. Now let's make it more complex. A landlord claims their insurance policy will be canceled or significantly increased if they allow a certain breed of dog. Can they deny the request? It depends. If allowing the animal would create a significant financial burden, such as losing insurance coverage, and no reasonable alternative exists, the accommodation may not be considered reasonable. However, this must be evaluated case by case with actual evidence, not assumptions. 2026. Insight. Reasonable accommodation does not mean unlimited accommodation, but it must always be evaluated carefully. Scenario 5. Documentation requests. What can you ask for? A tenant requests an assistance animal, and the landlord asks for full medical records and diagnosis details. This is a problem. If the disability and need for the animal are obvious, such as a guide dog for a blind individual, no documentation can be required. If the disability is not obvious, the housing provider may request limited and reasonable documentation that verifies the existence of a disability, the need for the animal related to that disability. However, detailed medical records or invasive information are not required. Key rule: ask only what is necessary, nothing more. Scenario 6. Access to common areas. A property allows an assistance animal inside the unit, but restricts it from common areas like hallways, pools, or outdoor spaces. This is generally not allowed. Assistance animals should be permitted in both the housing unit and common areas when needed for the individual's disability-related use and enjoyment of the property. This connects directly to ADA and accessibility principles. Equal access includes shared spaces. Scenario 7. Leash rules and control requirements. A housing provider enforces a rule requiring all animals to be on a leash in common areas. A tenant claims their assistance animal cannot perform its task while leashed. What happens now? The rule may still apply, but exceptions must be considered. If the tenant has a disability-related need for the animal to be off-leash, they may request an accommodation. However, the animal must still be under control through other means, such as voice commands or signals. 2026 standard safety and control matter, but flexibility is required when tied to a disability. Scenario 8. Can a request ever be denied? Yes, but only under specific conditions. A housing provider may deny an assistance animal request if the individual does not have a qualifying disability, the animal is not needed for the disability, the request creates significant financial or administrative burden, the animal poses a direct threat, the request fundamentally alters the nature of the housing operation. This ties back to Section 19. Denials must be justified, documented, and legally defensible. Scenario 9. Multiple assistance animals. A household requests more than one assistance animal. Is that allowed? It depends. If each animal serves a different disability-related need, or multiple household members have disabilities requiring animals, then allowing more than one may be considered a reasonable accommodation. However, if multiple animals serve the same function without justification, the request may be denied. Scenario 10. How to properly request an accommodation. From a tenant's perspective, requests should be made in writing and include documentation if necessary. Keeping records and following up is critical. From a housing provider's perspective, responses must be timely, reasonable. Based on the law, failure to respond appropriately can lead to a fair housing complaint. The pattern, where compliance wins or fails. At this level, the pattern is clear. Violations happen when policies are applied too rigidly, documentation requests are excessive, fees are improperly charged, assumptions are made about animals. Compliance happens when requests are evaluated individually. Policies are adjusted when required. Decisions are based on facts. Equal access is provided, bringing it all together. The 2026 Professional Standard. In today's real estate environment, assistive animal compliance is one of the most common and most enforceable areas of fair housing law. Your role as a professional is to recognize valid requests, apply the law correctly, educate clients and landlords, avoid unnecessary barriers, because in 2026, handling assistive animal requests properly is not just good practice, it is a direct reflection of your professionalism and legal compliance. Online discussion. Question 1. Why can't housing providers charge pet deposits for assistance animals? Answer: because assistance animals are not pets and are considered a reasonable accommodation under fair housing law. Question 2. When can a housing provider request documentation? Answer: only when the disability or need for the animal is not obvious, and only limited documentation is allowed. Question 3. Can a housing provider deny an assistance animal request? Answer: yes, but only under specific conditions such as safety threats, lack of disability-related need, or undue burden.